we come to the second part of our exploration of legal capacity, and we're moving on to the experience within South America, looking at Peru in particular, and some other reform processes that are happening in South America around legal capacity. It'll be looking at how the reform process is being driven, as well as what type of reforms are happening in those jurisdictions. And with us to explore these issues is Alberto Vasquez, and he's president of the Peruvian NGO Society and Disability Research Coordinator of the Office of the UN Special Rapporteur on the Rights of Persons with Disabilities. And I welcome Alberto.
Thank you. Good morning for everybody. I'm very glad to be here as a former student of this university. Three disclaimers at the beginning. First, I'm a lawyer, and normally I will apologize for that. So I will try to keep it more in terms of, I think, political science, in terms of processes, rather than a specific provision of the law. Secondly, I was supposed to talk about Latin America. That is a very huge area, so I will focus mostly in Peru, and also we will have a look at what is happening also in Argentina, Mexico. And the third one, I will use the word "we" a lot, because this is not only the work of one or two NGOs or DPOs. This is more the work, in the case of Peru, the work of the disability sector in general. So I wanted to start with this, with some very Asian background, because I think it's first interesting, and I'm very passionate with that. And it's about how we actually understand disabilities from different cultures. This is just, there is a picture there of a person with a physical impairment. And this is actually a chronicle from Guamán Poma de Ayala, who was a noble descendant from indigenous origins, but also from Spanish origins, and one of the first trying to explain how the Inca society, the society that actually ruled a very large part of South America before the arrival of the Spanish culture. So I like this chronicle because it says something that I think shows the link between not only inclusion of persons with disability, but also development and legal capacity. So this is my translation, because it was all the Spanish language, so let's see how it works. Everyone who could work and help will do it. He's describing the situation of persons with disability at this moment. Those who had eyes served to watch, those with feet, they walk, those with hands waving and serving as stewards and butlers, each will marry their equal to multiply and to serve in everything they could. And they had their crops, houses, and fields, and health of their service, and thus they need no hospital or charity, which is quite interesting for a society to actually organize the system where everybody should contribute. And I think it's very important how actually he highlighted the idea of property, which is quite linked to the right to equal recognition of legal capacity, and the right to marry. So just a small note on that. So I will talk about Peru and a little bit of context. It's a presidential and democratic republic, so we have three branches: executive, Congress, and the judicial system. It's a country with a 30 million population. According to the last disability survey, we have only 1.5 million persons with disabilities, but we know that data is collected in many countries that actually underestimating the numbers of persons with disabilities. And civil society pushed in the last 5 years for a new law on persons with disabilities that try to implement the CRPD in the country, but at the same time, it's not only about passing a new law, but it was more about actually changing other general laws, as the law on health, the law on education, the law on transport. So it was a very broad effort driven by civil society trying to change several legislations. And it's quite linked with the law reform I will talk about the reform on the civil code. And then at the same time, we had a big reform on the law on the law on general health that actually have now a provision on mental health that is trying also to implement the paradigm of Article 14 of the CRPD in our legislation. Actually, it says clearly that involuntary deprivation of liberty and involuntary treatment of persons with disabilities in general are forbidden. And to end this context, we have to keep in mind that Peru is part of the civil law tradition, and I would like actually to see and to listen to highlight what kind of difference we can face in terms of law reform, taking into account what kind of law tradition we have. Saying that, let's go to actually the subject of this presentation. In Peru, deprivation of liberty has been widespread, actually, not only from a law-based perspective, but also de facto deprivation has been very common. So the civil code at this moment declares the incapacity of a range of people, which is key, I think, when we think about law reform, because we tend to think about Article 12 as an entry point to discuss about legal capacity, but actually legal capacity and deprivation of legal capacity has been linked to other many groups. Drug users, or if you want to say the so-called persons with addictions, they normally also face a lot of deprivation of liberty, especially in liberty and capacity, especially in civil law context. The so-called prodigals, people who actually are deemed not able to control their assets in a way that actually ensures the means necessary to family to survive. So in many contexts, in Peru, for instance, but I know that in other countries in the Latin American region, are depriving of their legal capacity also. So if you want to start a law reform process on legal capacity, it will impact in these other groups also. And then the civil code, the Peruvian civil code have a status-based approach to legal capacity, which means there is a list of persons that will be considered incapable to exercise their legal capacity. And although they have some provisions that will bring the discussion more linked to an actually assessment of the mental capacities of the person, it is almost based under this status-based approach. And the consequence of deprivation of liberty, of deprivation of legal capacity, will be a curator or guardian will be established. Normally, as a practice, the judicial system was establishing a full deprivation of liberty. Although the civil code had some provision that opened the door for partial deprivation of liberties, of legal capacity, the tradition in the context of Peru was full deprivation of legal capacity. Access to justice during proceeding was denied, so the process normally will be started by the state or by the families, and the person will have to defend against them. But no legal aid is provided to that process, and actually the process starts with a curator or a process guardian, a procedure guardianship will be established to defend the person during the proceedings. The civil code also have other rights denied. So there are some specific provisions in terms of deprivation of the right to marriage. to marry, you have the provisions related to deprivation of liberty. But I think, as many on this room probably will agree with me, de facto deprivation of legal capacity was quite widespread. I was commenting during the break that many years ago, in 2010, the Ombudsman office in Peru started a proceeding against the state because I was working in that office at that moment. We found that 22,000 people with disability were deprived of their right to vote, but under an administrative procedure. Actually, it was illegal, but the idea was, because in Peru, the right to vote is also the duty to vote, so it's mandatory to vote in that country. So only a group of persons with disability who were deprived of the right to legal capacity through a guardianship process had to be out of the list of persons allowed to vote. But the register office decided we should make it easier for people so they can opt out to vote. So they took, in one procedure, 22,000 people out of the registered list. And it was quite amazing, because when we started this research, we found only 80 cases. But then when they actually provided us the information of the number of people, so it was shocking. And the idea behind this decision was, if a person in Peru cannot vote, then the person cannot do actually a lot of proceedings, as going to a notary, so you will get into contract with somebody, you cannot collect checks, you cannot do banking transactions. So depriving the right to vote was a way to actually depriving the right of legal capacity. So, and it was thought as a measure of protection. So this is a little bit of the context of the law reform process that we're facing now in Peru. So in 2014, the country set up a special commission at the Congress to review the civil code in order to implement Article 12 in particular of the CRPD in the country. This special commission was created by the new law on persons with disability. It was driven by civil society, and key stakeholders participated in this special commission, including 2 congresspersons, the judicial branch, the Disability Council, which represents the executive branch, the ombudsman person, a representative from academia, from law faculties, civil society, in particular DPOs, among others. I will explain later how we got there to this special commission, because I think that's actually the key part of this story. But I want to explain first what actually are we proposing in this commission. So we had I was a member also as a representative of civil society in this special commission. We had 1 year time framework, and we actually managed to have a proposal by March of this year. And the proposal is now in the Commission of Justice and Human Rights. So we're waiting to the open discussion in that commission, and probably if we get to the position of voting, this is must done, because normally the plenary of the Congress, we only have 1 chamber. The plenary of the Congress will pass whatever it has been passed in the Commission of Justice and Human Rights, because it's a very strong commission in the Congress. And it's a very ambitious reform, because it changed almost more than 80 articles of the Civil Code. Because as you know, in the civil law context, the Civil Code first is at the center of the legislation, and then the discussion about capacity, or lack of capacity, is at the center of the Civil Code. So it's a very key aspect of the Civil Code that will have effects in many of the chapters of the Civil Code, in the contract chapter, in liability, in obligations. So we have been working for a year, and now we have a final proposal. The final proposal, as I said, is a little bit ambitious. So we are recognizing it implies full recognition of legal capacity to persons with disabilities, but in general, all the other groups that has been affected historically by deprivation of legal capacity, which is important, and probably for people working in the civil law context will see it more obviously, which is important. We are keeping the difference between the capacity to hold rights and the capacity to act. So we're not taking the language of the CRPD, but because the tradition in the legal system, but we're recognizing full recognition in both cases. The proposal includes elimination of guardianship and all the legal restrictions, not only for persons with disabilities, but for other groups. And we are not making a new line between persons with high support needs will have a different treatment. Actually, it's full recognition of legal capacity for everybody. And in terms of support, the proposal have four key aspects. First, ensuring accessibility and reasonable accommodation for the exercise of legal capacity. And I think Gabor put very good examples about how only providing accessibility and reasonable accommodation, we can actually solve a lot of the challenges that we face in terms of barriers to exercise legal capacity. It includes also advanced directive, which means that a person that believes that in a future will need some support to exercise their legal capacity can actually decide at this moment, and it will be recognized. And following the recommendation actually of the CRPD committee, it will get into force when the person actually decides at the moment of filing the advanced directive. It also includes support agreements. It's inspired very close to the Canadian, but also South Australian experience in terms of not only having, it's not a representation agreement, it's a support agreement. So a person will get into a support agreement with a person, one or more persons, but also civil society organizations to get the support they need to exercise their legal capacity. This support will be officialized in a notary or through peace justice, but it's just an administrative procedure. And then we have a final measure of support, which is the judicial appointment. It may sound that the judicial appointment is close to the old paradigm of substitute decision making, substitute of exercise of legal capacity, but actually is more about an inquiry about what kind of support measure this person needs, because the person has high support needs. But even in those cases, the person actually can reject any support measure, and at the same time, the standard will be, even in those cases, best interpretation of the will and presence of the person. So for us, it was key to ensure that the bill includes a provision for no requirement of support measure for legal independency. So you don't need this kind of support measure in place, a formal support measure in place to have your legal capacity. In practice, we will see, and we can discuss that at the end, people will have the incentive to actually get a formal support agreement because it will make their life easier. But the law doesn't require that for actually have legal independency. And then in terms of safeguards, it includes the obligation of respect will and precedence, not only by support person, but other people interacting with the person, about the conflict of interest, which let's see how it works, because in many cases when we talk about families being part of, for instance, a support agreement, that will be very tricky. And then time limits and for all of these measures and review. This is a charter I just made about how was the expected impact, because I remember this from a class from Gerard Quinn, at the beginning of these discussions about a lot of people in many of the contexts actually needs very little support, but now they are deprived of their legal capacity. And when we think about accessibility and reasonable accommodation, probably we will solve a lot of the problems, not only persons with intellectual and psychosocial disability are facing, but all people actually in general are facing. And when I'm thinking about older person, I'm thinking about low-level support needs can be easily tackled by accessibility and reasonable accommodation. And then in terms of APAT directives, actually it was a requirement of people with psychosocial disabilities and DPOs thinking about that this could be a very good measure, trying to plan how it will work in times of crisis. And you have plenty experience in many countries, but the problem with this experience is normally it implies the idea of at some point you have no mental capacity to decide, and then the deprivation of legal capacity will start. But in this case, the idea is that the advanced directive will plan even that moment. And then in the terms of support agreement, the idea is probably we will have a lot of people going out of guardianship and trying to take this option, because this is a way, an easiest way actually to formalize some of the relationships that are happening now in the community. And then in the case of the judicial appointment, it was meant to deal with so-called hard cases. But it's important to note that you are not meant to actually, you need one of these. Actually, you can have different types of support, whatever. It's not mandatory to go to any of these types, although the last one requires to enter a higher standard to get into the process, but not necessarily mean that you will end if you don't want a support measure. I was planning to explain, and I will do, how we got there, but maybe we can stop here and try to talk a little bit about what are actually the challenges and the risk of having in place a system like this, because I think there is no example actually of a country having a complete reform that tried to get out of guardianship or curators or whatever system they have for substitute decision making, because in this case we won't have any measure for substitute decision making, even as Gabor said, in the so-called hardest cases we will work under best interpretation of the will and preference of the person. So I think it's a huge step in terms of what are we proposing in terms of law reform in legal capacity, but I can see a lot of problems in terms of implementation. We were discussing during the break with a friend about the risk of actually in the implementation people will sign a support agreement, but in practice it will work as ever, as families, friends, or state imposing their will in the implementation. So what type of measures should be in place actually to avoid that the implementation of this system won't drive us away of what were we actually expecting. And I think another question is, so how important is to have the right bill or the right law to implement change in legal capacity? My impression is, at least in the context of Peru, every de facto deprivation of liberty has some link with this presumption of lack of capacity, and the presumption of lack of capacity is very well known, comes from the civil code. So I think even the impact beyond the law reform itself will be broader, but we can discuss that. So maybe we can open a round of questions or comments, and then we will continue.
It's very interesting. I do understand the risk, and especially because you will be one of the first, if not the first country implementing complete reform on legal capacity. One of the things that keeps coming up and that we've discussed also is the need to document good practices. My question would be, what is your time frame to implement this reform? And in that period of time that will, of the implementation process, if you are planning to, for instance, start, I don't know if pilot programs, but some sort of documented cases which will help to continue educating, because I know you've done a lot of work educating the judicial branch, society in general, other actors involved like notaries, but this type of exercises that you can document will help to continue educating them and also for you to learn how to actually implement them in a way that is compliant with Article 12 and to what you wanted to achieve in the first place.
Somebody else want to comment something?
Yes. You know
Hold the mic, please.
you mentioned that the issue of there are a range of other, range of other capacities that are affected by the issue of limitation to legal capacity. But is it not the issue around intoxication and drugs is applicable to everybody else, and also issues of not being able to manage your affairs properly is also applicable to everybody else. So that argument I find is a little bit lopsided. Can you comment on that?
Sure. Somebody else, and then we can move. Or okay, I will go with both. Actually, the first one of Priscilla, I will explain it in a little bit later because I have actually some comments on that. But about drug users, for instance, I think it's a deprivation of legal capacity that is very linked with a presumption of lack of mental capacities. It is very linked, actually. In the case, for instance, the CRPD committee, in the case of Peru, commenting on a past law allowing deprivation of liberty that included both persons with disabilities and persons with addictions, stated that in the case of persons with addictions, there was a presumption of mental disability or psychosocial disabilities. So they will be covered by the CRPD with something that we can argue, and we can have a long discussion on that, but that was the statement of the CRPD committee in that moment. And actually in Peru, we had also a lot of cases and jurisprudence related to that in the case of persons with addictions, actually the link with psychosocial disabilities is very close, especially in terms of presumption of mental capacity, mental incapacity. I'm not sure if any of these provisions are neutral, actually. Even if you talk about prodigal that actually could apply for everybody, or drug user that technically could apply for everybody, if you keep it in a law reform as a provision, I think if you take out guardianship for persons with disabilities, but you allow it for prodigals or persons with addictions, you will end with a lot of persons with disabilities with a guardian because of those provisions. So it will be, now actually Peru, we don't apply so much in jurisprudence cases of prodigals, but I think the reason is you can apply the provision under deprivation based on disability. So I think not even in those cases it's a very neutral scheme, and it's very risky to keep it in legislation because you will allow, you will have an open door to apply it to persons with disabilities. For me, more interested at what are we proposing, and we hope we will get this before the end of the next half of the year. For us is how did we get there? Because this has not been a very short process, it has been a very long process. We started working on this since 2008 when Peru ratified the CRPD convention, the CRPD, the Convention on the Rights of Persons with Disabilities, and involved advocacy work with the Congress, the judicial system, academia, civil society, and media. And I would say that the key aspect was having a comprehensive strategy plus international cooperation. The role of international cooperation, funding civil society, was key. Even with very small amount of funding, as some of these organizations provide to civil society, grassroots civil society organization, you can do a lot. As I said, this process was civil society driven, and I will try to show some examples how it was done. In the case of the Congress, civil society presented a citizen initiative, which was quite complicated because it was quite easy to actually convince any Congress person to present a proposal to change in legislation in Peru, and everybody will love it because of the political leverage. But we took the risk of having a long process of 2 years collecting signatures, because that was a way actually to engage with civil society and grassroots organization. First, to discuss the content of the proposals, and I'm talking about the general law on persons with disabilities, but also it was about moving the machinery of civil society to be engaged in general in law reform. And for us, even if the law wasn't that good, that was a very good experience, because then we had a very committed civil society working in the streets, actually, collecting signatures and discussing and having a very clear goal and target. We made to got more than 100,000 signatures, so we presented the proposal. And then in the proposal, we actually designed how it will look the next step, because in that proposal that was drafted in 2009, we were thinking we need a special commission for the reviewing of the civil code. And we want a very calculated special commission. So we wanted the judicial system there, but also the ombudsman person, because we knew that the ombudsman person will be in the side of civil society, and we wanted civil society involved in that commission. So it was very well planned to have a very calculated special commission with the key stakeholder, because you cannot avoid, I think, to have the executive branch or to have the judicial branch. But you can have a more controlled environment when you actually ensure that people with disability will be in the commission. And then at that moment, we also advocated for the creation of a specific commission in the Congress, a regular one, not a special one, on social inclusion and disability. And that was key also, because that prompted a higher status of disability inside the Congress. So congressmen were more involved in issues of disabilities, because we had at that moment a regular commission. This was before the special commission. And in the picture we have first, actually the person I used to work, he passed out a couple of years ago, and he's holding all the signatures we got for presenting the citizen initiative. And then in the bottom is the special commission. And then we have been working very much since 2009 also with the judicial system, because we expected that the judicial system will play a key role actually supporting this kind of reform. If you want to change the civil code and you want to end guardianship, the first one that will oppose are actually the one that actually apply guardianship. So we started training with them at the beginning in a very informal way, but then we thought it would be very strategic to have the involvement of the Judicial Academy, because the Judicial Academy first gives these trainings recognition. Secondly, it will give them even incentive to participate, because they will have some bonuses for advancing in their careers in the judicial system. We did 3 diplomas on disability and human rights, and this year we had The first one on legal capacity and disability. And it has been great this year. We had 50 judges enrolled in that diploma. But we also advocated for a circular letter from the head of the judicial branch to actually prompt a higher discussion with all the judges. Even if we have a system that is based on the deprivation of liberty, are you really applying them in a way that actually can minimize the impact of the application? We weren't expecting actually that in a circular you will state that the civil code it was against the CRPD, but we actually achieved to have a circular that says you should apply guardianship in a very specific situations, and you have ensured review. So we were trying to reduce the impact of guardianship as a temporary measure until the law reform. And then for us it was key to get data, because you can frame your discussion in when you look up to what is actually happening in the ground. And people expected to have a higher number of people with disabilities under guardianship. And actually when we requested the data through the Congress, through the Special Commission, we noticed that only 8,000 people had a guardianship register. Probably we have more cases of guardianship, but not all the families register the guardianship because they just want the sentence to go to the administrative institution that is requiring the guardianship. But they don't want to actually register them because they know they will be deprived of a lot of rights. So, but that was key for us, because then the question was, why do you want to maintain a system that actually nobody is using? Because it doesn't answer, not even the questions of families about thinking about protection, and of course not the needs of persons with intellectual and psychosocial disability that were deprived of liberty. That was key for us. That was a way of framing the discussion in a different way. And probably with a higher number of persons with disability under guardianship, we will have to frame it in a completely different way. But I think even in those cases, you can frame your discussion in different ways. But it was key for us to the advocacy. And then, of course, strategic litigations. And I want just to comment one recent case of last week. A first instance judge just denied the incapacitation of 2 persons with psychosocial disabilities. And the judge was quite progressive. Actually, he was in one of these diplomas. And the judge said that the civil code contradicted the CRPD and the Peruvian constitution. And in regards to legal capacity. So the judge recognized first, which is, I think, very important, the judge changed the procedure to allow the 2 persons with psychosocial disability to be directly interviewed, to have a different type of assessment, not a medical assessment that was required, but also interdisciplinary assessment to actually understand what was the context of the family, what was the context of inclusion of each of them. And during the interviews, he realized that this is a case not about legal capacity, this is a case about access to pension. The family is requesting the guardianship because an administrative body is requesting a sentence and a guardian to access to pension. So I think that was key in this case because the judge recognized that the right to pension cannot be subjected to any deprivation of legal capacity, which accordingly some research we have done in some of the courts, it could be even 80% of the cases related to access to social security. And you can see then the link about access to social protection and deprivation of legal capacity. And then the judge says, okay, we will grant full recognition of legal capacity of both defendants, but he pointed out the need for support. And we can argue that that could be a very risky because it was not required by not even by the defendant, or the complainant. But he established a support system in accordance he claims with the defendant because they expressed their fear about control of property. And so he established a system that involved both family members, but the interdisciplinary system of the judicial system, which is good, I think, is that he recognizes this is a temporary measure, and we have a set-up system where actually we can use and decide in a better way. And because of that, actually, the judge requested in the sentence to the Congress to inform what was the situation of the law reform process, because for the judge was key to have clear legislation to actually reduce the scope, and we're talking about civil law context, the scope of the judge deciding of on this kind of cases. And then the judge put, and this could be controversial also, that some qualified decision related to property, in particular to the house these two persons had, require co-participation as opposite to co-decision making. So it means that the support system must to be aware and must to be notified and must to be present, but these two persons can actually avoid their opinion, but at least they have to be notified and present to make their own decisions. Which is also good is the judge put an automatic review after 6 months, which is quite short. Normally you will see that it's 1 year or 2 years, but in this case it was 6 months. And then it introduced for the first time in Peru a sentence in plain language, which actually is completely easy to read, I think, especially for non-lawyers, because in general, sentence could be very cryptic. So I think that was part of the impact, and we expect that that will reinforce the process we have at the Congress. And we have been working also with academia. Actually, OSF is funding a legal clinic in the Catholic University of Peru, and they are also working on some cases. But with them and my organization, we did some diplomas and courses that actually also foster the involvement of the university in these issues. And that was key because we needed, and we knew it, key lawyers engaged in this discussion. You know, if you want to go and to discuss legal capacity, it's important to have persons with psychosocial disabilities and intellectual disabilities, but we needed also people that actually are very engaged in the academia and very respected to be engaged with this new paradigm. And finally, in terms of civil society, it was key for us that persons with intellectual and psychosocial disability were at front. There is a picture there, or actually one of the organization persons with psychosocial disabilities in the country. And we're working together. We set up a working group on legal capacity, trying to strategize together all the actions. And we came out actually following the example of Ireland, principle for law reform on legal capacity that actually put a line of what we wanted in the special commission for the law review. And actually, at the end, many of these principles now are in the bill. And finally, media. We have been campaigning during this process, but focusing in pointing out the negative aspects of guardianship. For us, that was key, to convince people this is not a system you want to maintain. And then, because when you have that discussion that this system is actually not working for anybody, then people will ask, so what is the solution? And then you came out with your proposal. But we were trying to create the need for the reform. So in one of these cases, there is 3 photos there. The first one is a person with Down syndrome that actually finished university, and because he's a person with intellectual disabilities, he wasn't allowed to create a business, to register a business in a notary, because most of the notaries will claim that they cannot do it because the civil code states that these persons are deemed as not capable. So that was a good case for us because it showed how actually, and it was a little bit manipulative because it was all about how deprivation of legal capacity actually can cut your opportunities. So even when you have a lot of opportunities in life, like in this case, that you went to inclusive education, you even finished the university, is the first person with Down syndrome that finished the university in Peru, and then even in those cases, you will have to challenge this presumption of lack of capacity. So we have been working on these kind of cases, trying to get attention in the media, and it was quite successful, I think. What is missing? A lot of things. We didn't engage a lot with older persons. Probably demographics in Peru help us because we have a lot of youth in the population, but it's a pending issue. And also, private sector has been engaged to some extent, but not necessarily are very aware about the reform we're doing. Actually, it will have big impact in terms of discrimination and discrimination in access to goods and services. With notaries, we had some work. Actually, now they are very engaged, and it was very strategic for us to put them as part of the system, because then they got engaged. They thought, they saw an opportunity in the reform actually to get more work, of course. But also, we got engaged with people actually from the notaries doing some research on the impact of the civil code. Families, we have been working a lot with DPOs, a person with psychosocial disabilities, intellectual disabilities, multiple impairments, but we have been kind of avoiding the discussion with families, and probably because they are not very well organized in many areas. And now we're trying to do that, to actually trying to explain them how this system actually benefits them in many aspects. And then the question of Priscilla, community-based experience. We are just starting. That's why in the drawing is a big circle I just put there, because community-based experience are very important to actually show how a support system can work and should work. Only the Peruvian Down Syndrome Society, Down Syndrome Society is working now and develop a pilot of a support system for some of the persons that actually are engaged in that organization. But I think that's the weakest point of the process. This is not the only country that is doing this in the region. Actually, Argentina, Mexico, but also Colombia have now some proposals for law reform. Not all of them are in the same line, and I just want to mention very quickly, because I know I want to have time for discussing this. But in Argentina, they had a window of opportunity because they had a very old civil code from 1871, and they had a law reform process last year, 2 years ago. So actually the disability sector faced the opportunity to include more progressive measures in the new civil code. But they had before that a growing jurisprudence of many judges actually challenging the civil code using the CRPD in a way to change the proceedings, and in a way to also impose support measures instead of substitute decision-making measures, which again I think is quite risky, because then you can actually water down all the concept about what is support in terms of the CRPD, which doesn't mean that it will be imposed in a person. But they have a growing jurisprudence on that at least is closing the gap between the CRPD and the old paradigm, if it is possible. They also had new mental health legislation in Argentina. They passed new mental health legislation 2 years ago or 3 years ago. It follows a lot, I think, the old paradigm, but also it follows a lot the experience of the common law, especially in UK and other countries. I don't think it's complying with the CRPD, but it has changed, and I think that's part of what is missing in the proposal in the new civil code they have. because they have a window, because as I mentioned, they had this window of opportunity. They managed to include some provisions in the civil code. So they had not full recognition. They have a presumption of legal capacity, which is not going very far in terms of international standards, but for Argentina was a huge step. We can discuss that if we want small steps going to the new paradigm, or we need actually a long-term reform that actually guarantee full recognition. I think that's open to discussion. So they had an exceptional limitation of legal capacity when it's in their benefit, which is quite close to the best interest standard. And they have now two standards of the deprivation of liberty: restricting capacity, which means actually partial guardianship. They had before they only had full guardianship. The difference is, and I think that's the very risky part of this reform, they call support what actually is a substitute decision, because they require the guardian to actually follow the wish and preference of the person, which doesn't mean that the person has legal capacity. And then they have exceptionally the possibility to get a guardian. And the system goes with a judicial procedure. If you go to the judge and the judge thinks you need a support measure, it will be imposed. And the only way the judge can impose a guardian will be if the support measure doesn't work. My impression is we're not going very far with this, but that has been the reform they had. I think part of this is because it was a complete reform of the civil code, so you had actually all the civil lawyers involved in this reform. So it wasn't only about legal capacity, it was also about contract law, it was also about liability law at the same moment. So I think you have a less controlled environment for these kind of discussions. But Mexico is also doing some things, and we have somebody from Mexico that will help me maybe with some of the questions. First, they had a big case in the Supreme Court. An autistic person, a person with diagnosis of Asperger, challenged his guardianship. And actually the Supreme Court ruled that guardianship itself, it wasn't against the CRPD, but the way it was being implemented and interpreted was against the CRPD. So the case opened a discussion in the country about what is implementing the CRPD in terms of legal capacity, but also pointed out many of the weaknesses, not only of this case, but also the implementation in general in the country of the guardianship system. After that, a couple of initiatives of the Legislative Assembly of the Federal District of Mexico. In Mexico, you have different legislative assemblies for each of the states. Proposed a couple of reforms of the civil code from the Federal District of Mexico. They weren't consulted with civil society, and at the end, they weren't approved. But that discussion led for a new proposal of a working group on legal capacity from civil society. I was just reading it yesterday, and I think it's quite interesting because for me it's at some point very close what is being discussed it has been approved in Argentina. As a general measure, it established general recognition of legal capacity for all, and it cannot be restricted, it says, on the basis of disability. But at the same time, the proposal starts with a presumption of legal capacity for adults. And we know that legal capacity can be deprived in some cases. And actually, the CRPD doesn't imply that you cannot deprive legal capacity. What you cannot do is deprive legal capacity on the basis of disability. But then the law established some exceptional restrictions on limitation of legal capacity. And they work with two concepts: sickness or disability plus the assessment of the individual circumstances, and then the ineffectiveness of support. So when you have all these concepts together, you actually open the door for a restriction of legal capacity. And then again, the idea is, even in those cases, going closer to the paradigm of support, which I think could be not clear and even could be risky. They put some safeguard, but actually it's a safeguard for the restriction of legal capacity, not for the implementation of support measures, shortest time possible, right to be heard, reasonable accommodation, support, and due process. And they also came out with the idea of the right of person with disability to access to support for decision making, and that was the wording. And then I think opens again the question, actually only person with disability needs support or not? I think this is a very important question we have to bear in mind when we do this kind of report, of proposals. And as in the case of Argentina and Mexico, they don't have concrete examples of how the support system will work, because it's meant to be developed in administrative provisions and in public policies. But I think it just have a broader concept of support that we cannot envisage what is going to be the outcome. So the idea of presenting all of this is to have, I hope, some discussions about, do you think we will have a different context of law reform under a common law context or a civil law context? I have that question always, because I think it makes some difference. And then, what is the best strategy? Sometimes you have a window of opportunity and you want to take it, as in Argentina, but then you will do some steps in the right direction, but then how long will you be stuck with that? I think that's a big question. But then if you want to do a long process of Peru, then you need a lot of time. It's time consuming. It really needs the compromise of a lot of institutions. So I think both of them have some challenges and opportunities. And also it creates the question about transition processes. So if we pass new legislation, what is going to happen with people under guardianship now? Or do we need long transition process? We were discussing about deprivation of liberty and how people living in institutions to live in the community. Some countries tried to have transition process, but at the end, the transition process was a permanent process. So how to manage that in the case of legal capacity? I think that's another big question. And finally, what will be the reaction of the system in general? In Peru, we have been trying to control that reaction. But as I said, we have the private sector there, we have families, we have other actors, and it's impossible actually to have an answer for everybody. So I think that's some of the challenge we're facing. And I would love actually to listen some of your questions or comments or...
So, down the front here, and just to the left.
Hello, my name is Madalina Turza. I am Executive Director of the Romanian NGO called European Center for the Rights of Children with Disabilities. And first of all, I want to congratulate you for, of course, for your presentation, but most important for the hard work on the reform and for this leading reform that you are doing concerning the legal capacity. I'd like you to ask one question. We are facing now a small debate about legal capacity in Romania of persons with disabilities. Unfortunately, we missed the window of opportunity because we have just modified the civil code. We are at the level of Argentina right now from this point of view. And I wanted to ask you from this point of lobby strategy that you implemented, how did you manage to mobilize lawyers in this action? Because in Romania we have this big challenge to have legal practitioners and lawyers involved in all the aspects of human rights and disability in particular. And basically, when you come only as a civil society representative, as an NGO, or as a parent of a child with disability, as myself, you are not perceived as a very convincing voice and actor. And how did you succeed to involve so many lawyers, one? And secondly, I saw that the judicial system cooperated very well with you. Maybe you can share with us a little bit from the insights of how did you manage to do that. And also, I wanted to ask you if you used as an argument in your campaign also the situation of institutionalized person with disabilities. I don't know how it's in Peru, but in Romania, they do not have legal capacity and they are represented by different representatives of authorities. And we have huge problems here in the area of institutionalized persons. So if you can give us a little details, thank you.
Do you want to just take that one since it's got 3 components?
Yes, maybe.
Then we'll move on to a
Okay.
couple more.
As I mentioned, and I will try to develop a little bit more, we started working with the universities. In particular, one faculty of law, we convinced them to have some training courses, some diplomas. Actually, we were targeting human rights offenders. Actually, we were providing them, because I think that's the link with international cooperation. So we managed to have free courses, training courses, with a certificate from a very qualified university on disability, on the rights of persons with disabilities, on the human rights of persons with disabilities. And we did that with the judicial system, because normally judges have to pay even for training course with the Judicial Academy. But in our diplomas, they are for free. They have international professors in many cases, and you get credits for promotion. So it was a very, I think, strategic way to engage them. And then it's all about the content, because of course, if the course is not good and the training is not good, it won't work. But then there was a decision of Open Society that they were trying to replicate the model of legal clinics that they had in Africa in Latin America. So the same university that was working with us started a project on legal clinics. And probably what chose it because they had this training before with our NGO, and we worked together. And then for that, we thought, well, we need to engage some of the major names, because I'm just too young to go to the Congress and try to convince everybody. So we needed actually people very respected in the law community advocating for this reform. So we got engaged with a couple of them. Some of them at the beginning quite convinced that this was impossible, that the system actually was in compliance with the CRPD. But then when you talk, I think, with very qualified people, they will realize very, very shortly that they didn't know something about and then they will try to be the experts on the subject. So now we have these converted human rights defenders very strongly on legal capacity. So that was the case of lawyers and academia. But then with the judicial system was harder. At the beginning, we started doing these small workshops. It didn't work that well. And then we thought we need the Judicial Academy. So we used a Congress person as a leverage to open the door and a discussion with the Judicial Academy. And then we convinced them to do some trainings in a formal way with certificates from the Judicial Academy, but pay all by us. So we will pay all the course, we will pay all the professors to just provide us the space to do this work. And then after the first one, and actually we were begging for money with many institutions to do that, then Open Society came and says, okay, I want to fund this because it works. And then we have new jurisprudence because some judges are going through these courses.
Okay, just keep to the side.
My name is Francis, and let me join my sister from Romania to say thank you for such a brilliant presentation. I have a couple of questions, but they are more like where she's coming from. But first, I want to know what provisions in the Peru laws that give the appointments of judicial actors, because you mentioned about appointment of judicial actors. What laws, which laws provides that, and how it is being done, whether it's done by civil society inclusions. There's one. Two, as you mentioned, with the judiciary, were you very much, quite, I would say you were, I must say, maybe lucky, or maybe because of the work we are doing, to kind of cross that barriers with the judiciary to be able to have the approvals in our suggestions of the legal capacity. Because in my country, I have been trying to push for a practice which is very common in Latin America, of course, in Malawi and other places, paralegal practices. They have been quite very, very difficult, especially with the laws, with lawyers who are more like very defending their profession, to say that if you build legal capacity, or you say the legal capacity of perhaps individuals or civil society, you are more likely taking their jobs from them because they were clients in the community and so forth. So how quickly were you able to cross those barriers? And I would love to learn more from you. Thank you.
Okay, just here in the middle.
Hi, my name is Sika. I come from Iceland. I've been interested in when the Congress and the ministries became involved. And so it seems like that was after academia and the judicial system had already been handling these questions. And also civil society and media. Was their role played throughout the whole process, or sort of as it went on?
Okay.
Thank you very much. My name is Ada Obi. I'm from Nigeria. I'm just curious. I noticed in your presentation with the judicial system that there was no engagement with the police and the criminal justice administration, because you notice that that's a very crucial area as it relates to persons with disability being in conflict with the law and where there's an abuse and deprivation. Secondly, I also noticed when you talked about the community engagement. When you talked about the community engagement, excuse me.
That could be any phone around you, so
Yeah, I noticed.
yeah, it may not just be you.
Thank you. And secondly, I also noticed in the community engagement that there was nothing about the institutions, because legal capacity plays a lot of roles in terms of psychiatric homes and private homes, where it comes to deprivation and voluntariness of remand. So I'm just curious to know why that wasn't engaged. Thank you.
Take those three.
Yes, maybe.
Thank you.
Four. Okay, I will start with the last one, because this is the strategy we had for law reform, and actually engaging with the judicial system will have different impact beyond the law reform, but for us it was key for the law reform. And that's why we didn't engage actually so much, because at the end you cannot tackle all the problems. I think you need different strategies for each of these cases. So we prioritized these aspects, these different aspects: Congress, judicial system, academia, civil society, media. We didn't, and I think that's something missing. That's something missing, because in practice you will change, you will face that problem. And even in the case of the judicial system, we have been focusing a lot in judges working on civil law, family law, but not necessarily people working on criminal law. So I think that part is also missing. We wanted actually the engage of the judicial system during the process. We wanted some judges making the difference, but we know they at some point the judicial system have to take the lead on that, because that has been very civil society driven. Of course, as part of the strategy, normally we will never put actually our logos or our work in front. It will always be the judicial system is working on the inclusion of persons with disabilities, because what's part of the strategy, to engage these institutions in a way they feel they're moving on this, and they are actually the champions working on. And I think even open just the door for us, it was great. So there are a lot of things missing, of course. And then in the case of institutions, Peru doesn't have so many institutions. We have some institutions for welfare, but I think we don't have more than 400 people living in institutions in a country of 30 million. And because neglect and abandonment of persons with disabilities is the rule, so it's all about families or people living in the streets, so it's a different context. We still need to work on that, and I think that's a discussion different on Article 19, but that's the reality in terms of institutions. That's why it wasn't a key aspect of this. It's the same with, we don't have public guardians, so normally families will carry the responsibility of being a guardian. We don't have, Argentina has thousands of public guardians, so they have 1,000 people under guardianship, because then it becomes a business. Or a burden for the state, but actually in our case it's family, and that's why family will try to avoid to have a guardian for the relative with disabilities. In the case of the judicial system, it was a very slow approach. We started in 2009 with small training courses, and then we did this first diploma as a pilot, funded completely by us, as I said, with money from 3 different organizations on international cooperation, but actually doing work for them to get some money to do the courses. And then it was easier because they saw that we had a very good standard, bringing people from other countries to show their experience, involving people with intellectual disabilities and psychosocial disabilities during the classes. So the feedback from the first course was key. After the first course, actually, people joined the last one, and it's quite impressive that the last diploma in legal capacity, we launched the call on Monday, and on Tuesday it was full. Actually, we were expecting to have only 35 people, 35 judges enrolled, but we had 50 and we couldn't avoid them to be part of the course. And I think it was because of the first one. And then people get engaged, and the feel, I think, convincing people that actually they are making the difference is key. Because when people believe that it's somebody asking you to do something, it's completely different. But when people feel, okay, I'm making the difference, and they are actually valuing my job, Because then with media we will say, this judge just ruled an amazing sentence that is changing jurisprudence in Peru. And we will put the judge in the front, which means a lot of attention. And we do the same with the Congress, we do the same with the Academy, because we want them to feel that actually they have there is some value beyond the general principles of inclusion and human rights, or actually the rule of law, but beyond that, they have a personal value of that. And I think that's key also to engage with people. And that's how it worked. At the first course I was teaching, and I was very nervous 6 years ago, because judges tend to be older. But they were quite engaged at the end of the courses, because I think they felt there was some knowledge there they didn't have. And then when you just touch that part in people, that actually is for people that is very important to have the knowledge, and then you can open a good discussion.
Are you happy to take 2 more questions? Okay, we have one here in the middle, and then we have one after that.
Yes, first of all, thanks for this presentation. It was really interesting. I'll have to get back to you on more information on this process, because I think it's a process that will have to happen in Germany very soon. And I really thought it was interesting how the bottom-up perspective, how you try to involve every stakeholder. My initial question was already answered, because I was about to ask if you have public guardians or professional guardians, or if it's only done by family. Because I think Francis pointed out a very important point, because in Germany there are professional guardians, and they would have like a natural interest in keeping up the system, even just to keep the job. So that would be an interesting point in changing in law reform, how to involve them in the process. But also in regard to family guardians, I guess it's an important aspect, because he did mention that they weren't too involved in the process, so that might be a very important next step to involve them. Because he said most families avoid to get a guardianship, but there might be families that, so I was wondering if there's any, networking with them or involvement with them. Thank you.
Okay, thank you. And one last question from the back.
So thank you from my side as well for this most interesting presentation. I would like to go back a little bit to your last slide around the Peru reform, where you were mentioning the elements missing, and one of them was older persons. And I think I missed your point around that, and what was exactly missing? Was it that older persons were not consulted, or was it that the reform did not address their challenges? And the reason why I'm asking this question is actually that my experience comes from the aging sector, not the disability sector. And I work for an NGO in Brussels, which is the network of organizations of older persons. And what we witness in our work within Europe is that older people fall in between the cracks. So we face a paradox where we hear from policymakers at the national and European level that older persons are covered by the CRPD, or should be covered by the CRPD, because majority of them face some kind of barriers limited to their age-related functional limitations. But in reality, the CRPD implementation does not take into account the specific situation of this group. So what we see is, for example, that there exist age limits in access to social protection benefits, which have not been addressed either by national governments, not by the CRPD committee. Older persons are not consulted in national reforms, and older persons are not even aware of their rights and how they can claim them under the convention. So I was wondering if you can just clarify what you meant around Peru, but also, since you're very well placed with the 2 hats around, the NGO hat that you work within, the Office of the Special Rapporteur, how we can improve the application of the CRPD for this group, so that we don't miss the opportunity and that we equally apply disability rights across the life course.
Okay, I will begin with that. In the case of Peru, we couldn't find a very strong organization of older persons involved in human rights, and I think that's a challenge in general everywhere. I was involved for one reason in the process in the Latin American region, because we just passed a new Inter-American Convention on the Rights of Older Persons. And it was quite difficult in 2012 to actually convince the working groups and some of the organizations to change the language about the right of having a guardian or the right to live in an institution, because the paradigm was completely different from that point of view. And at the end, the new convention, the Inter-American Convention, had a language that is very mostly in line with the CRPD, but it was a lot of effort in terms of actually stepping in an area that it was beyond our expertise, just trying to avoid to water down the standards of the CRPD, and I think that's going to be a challenge everywhere. But that was happening in Peru, and of course, I think the fact that in Peru, the rights of older persons is a new subject. We have new organizations, but there is still work more in peer support and sport activities, sharing, but not necessarily working on a human rights-based discourse. So I think we have to get engaged with them for many reasons. I think that the fact that disability affects in Peru is at least 50% of the population with disability is older than 60. So we have to recognize that. But then it's not that easy to get engaged in. I think we need to explore more. I think the African context gives you a good example how probably the outcomes of the protocols they are developing on the rights of older persons and the right to persons with disabilities are a little bit different in terms of some of the standards.
Public guardians?
Sorry?
Public guardians. I thought you, no, I said public guardians, the other question. Did you want to address that?
Yes, sorry. About public allies?
She mentioned public guardians.
Yeah,
the public guardian. Yes, we don't have that, but I will, and the families, of course. And I think it's not true that we haven't been working with families, but not with family-based organizations. We have been working with the most, for organizations, for instance, persons with intellectual disability, but that actually have persons with intellectual disability on the board and making decisions and working under the paradigm of the CRPD, not with more traditional family organizations that actually are, for instance, claiming for institutions because they don't have where to go. For many reasons, probably because in terms of strategy, they are not that strong. So we knew at that moment that they won't make a difference in terms of implementing or advancing the agenda. But of course, in terms of implementation, actually, we have to work a lot. And that's why I put a big circle of community-based experience that actually implies a lot of working with families and communities. And for me, that's also key. When we were planning the structure, talking about the structure of how do you want to place support in a system, we were thinking, if we have a bad experience with the judicial system, and of course we will need them, we shouldn't put that the access to support have to go always through the judicial system. Actually, you want to put it away from the judicial system. And at the same time, because we thought families not necessarily recognize decisions or allow the capacities of persons with disabilities to make decisions, we wanted to involve, even in the designing, that you can choose even civil society organizations to provide the support you need. So trying to engage in a broader way, taking out necessarily from families, especially that was the case of persons with psychosocial disabilities advocating, we just don't want to keep it that way. Let's be more open about having civil society organization as peer support organization that actually can provide me the support I need. So I think the designing is very important to see what are the weaknesses of your country. In our country, it was the judicial system. You don't want to go to the judicial system to have a support agreement, or you don't want to go to the judicial system to recognize an advice directive, because it will take time, it will take money, and then you don't know what's going to be the outcome. So just keep it to the minimum. So we're just using that for some of the cases, but not necessarily for all the designing. And I think implementation, it will be complicated, but first we have to pass it. So we're now in the Commission of Justice. I think the fact that because we took this long process, actually the judicial system is supporting this, the executive branch is supporting this, at least two parties in the Congress are supporting this, but still we need to convince, of course, all the members of because you can have even the president supporting this, but then you need to convince the particular congressmen that are sitting, congressmen or congresswomen that are sitting now in the Commission of Justice. But that's what we're facing now. So we're just in it's a huge commission. They have more than 200 projects. So that's why we're putting a lot of pressure in media that this has to be addressed now, because the Congress will be renovated next year. So we want in July. So we want to do it before the Congress change. Otherwise, we will have to start with the congressmen again.
Thank you. I'm aware that there were a couple of other people that had questions for Alberto. Hopefully Alberto will be available throughout lunch and this afternoon if you wish to pin him down and ask more questions. But thank you very much. It was really enlightening the way you were able to tease out the complexity of reform and the challenges for implementation. But I think it was excellent the way you highlighted the importance of being able to give space and forum to be able to engage in the discourse. And the discourse isn't just about with the executive arm of government and so the people that are making the decisions. It's also a discourse with families, with vested interests like public guardians and guardianship bodies. But more importantly, having the best pieces of paper in legislation that you can have, you still need a judiciary that will implement that and apply it in the most progressive way possible. And so having those resources and those opportunities to be able to create those forums and create those opportunities for discourse is incredibly important. Thank you very much, Alberto.